This is Barry Zalma, Zalma on Insurance. I'm an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today, March 1, 2021, I published, along with Claim School Incorporated, Volume 25, Issue Number 5, of Zalma's Insurance Fraud Letter, which is available from my website at zalma.com. The main article in today's fraud letter is an article entitled Insurance Fraud by Insurers. Insurance fraud is not limited to fraud by insureds against their insurers. Much to the shame of the insurance industry, the reverse also happens. The poster child of fraud by an insurer was Martin Frankel, who created a scheme he masterminded to loot more than $200 million from 7 insurance companies that he controlled. Franklin American Corporation and its wholly owned subsidiary, Franklin American Life Insurance Company, were controlled by another entity, a Tennessee trust named the Thunor Trust. The trust had purchased an 85% interest in Franklin American in 1991. In subsequent years, the Thunor Trust purchased 5 other insurance companies which were domiciled in the states of Mississippi, Missouri, and Oklahoma. Between June 29, 1999 and January 14, 2000, the insurance companies mentioned above were ordered into liquidation by the courts in the 4 states in which they were domiciled. Martin Frankel, the man who allegedly controlled a financial empire that included insurance companies, a securities trading firm, a nonprofit foundation, and the Thunor Trust, was indicted in both state and federal courts for fraud, criminal conversion, and for allegedly looting at least $215 million from the assets of the insurance companies. Frankel's scheme to defraud the insurance companies, those it insured and its investors, began in 1991 and lasted nearly 10 years. It involved the participation of dozens of co-conspirators and ultimately resulted in the insolvency of the insurance companies. In broad terms, the scheme worked in this way. Frankel obtained control of the insurance companies and, once in control, placed 2 of his co-defendants in positions of authority as CEO and CFO, respectively. Those defendants then stole the insurance company's money through a series of financial transactions. To commit their fraud without detection, Frankel created sham companies, used alias identities, and had numerous mailing addresses for phony companies and identities. These defendants transferred the money from the insurance companies to banks or brokerage houses in the United States, and from there transferred the money to foreign banks, usually in Switzerland. They then transferred the money back to the United States, where it was converted to untraceable cash for their own use and to fund their fraudulent scheme. Eventually, Frankel was convicted of multiple crimes. He appealed his conviction only to have the Second Circuit Court of Appeal affirm his conviction. The Second Circuit noted that Frankel took down others and others found it profitable to run a fraudulent insurance company. For example, in U.S. v. Kim, a 2003 decision of the District of Connecticut, following a 2-week trial, defendant Mona Kim was convicted of 7 counts of crimes which arose from her participation in a scheme to defraud insurance companies and investors. The government's indictment and prosecution of Kim was based on her participation in Martin Frankel's scheme to defraud various investors, financial institutions, insurance companies, and the shareholders and policyholders of those insurance companies. The witnesses and documentary evidence established Kim's involvement in Frankel's scheme to purchase life insurance companies in various states and do so without disclosing to regulators or the public that Frankel would own the companies and manage their financial assets. The evidence produced showed that the defendant's participation in Frankel's scheme by assisting in the conversion, theft, and embezzlement of insurance company assets by using an alias of Monica Kim to assist Frankel in falsely representing that the assets were on account with Liberty National Securities, one of the entities in Frankel's scheme, and by establishing, maintaining, and employing bank accounts under Frankel's control. The facts deemed necessary to an understanding of the issues raised in the motion were set forth in greater detail, where the court stated upon a review of the record, the court found the government introduced sufficient evidence, and from the evidence adduced at trial, a reasonable jury could conclude that the defendant was a separate culpable party from the Frankel enterprise. Frankel's enterprise was not limited to the commission of the wire fraud and money laundering transactions, but also included market research, running insurance companies, gathering data concerning financial markets, and conducting special projects activities, all of which provide ample links between the members of the enterprise, which extend beyond the commission of the charged racketeering activities. Further, the fact that separate and distinct entities, indeed the Second Circuit expressly found that the proof used to establish the pattern of racketeering activity element may in particular cases coalesce with the proof offered to establish the enterprise element of RICO. In Chow v. Day, a 2006 decision of the District of Columbia Circuit, the District of Columbia Circuit Court dealt with a case brought by the Secretary of Labor under the Employee Retirement Security Act of 1974, ERISA. The Secretary filed a complaint in the United States District Court for the District of Columbia against Day, alleging that he violated his fiduciary responsibilities through an illegal scheme to misappropriate insurance assets. Specifically, the Secretary alleged that Day accepted hundreds of thousands of dollars from 29 ERISA-covered employee benefit plans for the purpose of purchasing insurance for the plans. Under his brokerage scheme, Day sent invoices to the plans for various insurance policies. The plans paid the bills by sending checks to Day, and Day deposited the checks into his corporate account. Instead of using the plan checks to purchase insurance, however, Day kept the money and provided the plans with fake insurance policies. The district court granted the Secretary summary judgment and ordered Day to pay over $1 million in damages. Day claimed he was not a fiduciary subject to the law and appealed on that issue only, apparently having no defense to the issuance of fake insurance policies. The D.C. District Court found, quote, as the plan's agent, Day was bound by broker's common law fiduciary duty to faithfully deliver the plan's assets to the insurer. The court found that there is a fiduciary relationship between them, and the agent or broker has a fiduciary responsibility to the insured. The D.C. circuits affirmed the district court because Day was a broker who solicited, accepted, and then pilfered the plan's assets by reneging on his promise to purchase insurance for the plan members. Because Frankel's enterprise was not limited and also included market research and other things, They caused the defendant to be convicted, and the conviction was affirmed, and Mr. Frankel spent a long time in federal prison. Now, these are very unusual crimes when insurance companies commit fraud to steal from their insureds and their investors. But it does happen, and people must be aware. In addition to the stories about crimes by insurers defrauding insureds and the owners of the insurance company, this issue of Zalma's insurance fraud letter includes an article about kickback schemes that resulted in multiple insurance fraud convictions of an insured who was trying to steal from his insurer, some wisdom from the ages, the New York State's Legion of Shame listing 10 really bad insurance fraud perpetrators, good news from the Coalition Against Insurance Fraud, the Coalition Against Insurance Fraud's Fraud of the Month for the month of February, a listing of multiple health insurance fraud convictions, because Zalma's insurance fraud letter only reports about convictions, not arrests, since people arrested are presumed innocent until they are proven guilty. We also report on videos from Barry Zalma on YouTube and Rumble, other insurance fraud convictions not related to the health insurance industry. One of my new books, It's About Time to Abolish the Tort of Bad Faith, and other books written by Barry Zalma, as well as articles posted on Zalma on Insurance, the blog, which is available at zalma.com/blog, and has a new article added approximately once a day or 5 days a week. If you found this video to be of use to you or of interest, please forward it to your colleagues. And please subscribe to my YouTube channel and my Rumble channel and my blog so that you can be advised of future blog postings and videos. Thank you for your attention.